Have you ever received a notice from the government that you violated a rule you didn't even know existed? Maybe you parked in a restricted area that wasn't clearly labeled, so you file an appeal. But the appeals process can be time-consuming, and it might make you wonder if it's even worth the cost of hiring an attorney or the effort to fight the parking fee. Official processes can be long and painstaking because justice and good government take time. But in this episode, we'll hear about the Boucher family, Indiana farmers who cut down 9 trees on their property in the 1990s. When the US Department of Agriculture learned about it, they thought the Bouchers might have damaged some important environmental resources, so they began to investigate this potential regulatory violation. Probably neither the Bouchers nor the USDA could have guessed at the time how long this process would take.
The Bouchers were a family of farmers. They interacted with the United States Department of Agriculture in a number of ways, as most farmers do. They cut down some trees on their land in the 90s.
Mr. Boucher saw that there was a piece of ground where there seemed to be garbage collecting, and people were dumping stuff there. And so he said, I'm going to clean up the brush, going to cut down some trees, and maybe that'll help.
And so he removed the trees to eliminate the cover for the passersby so they couldn't dump in his field. Not to farm the fields. 4 trees was not seriously impeding the ability to farm. He removed them just to try and clean up the property and make it more presentable. In 1998, he removed the remainder of the trees from UN2, primarily for the same reasons, but also because at that point, he was farming the field anyway, so he might as well go ahead and remove the remaining trees.
And then over the course of the years that ensued, they learned that the USDA thought that doing so had actually interfered with a wetland on their property as a farm.
Now, why would the government care about a farmer couple removing a total of 9 trees from their property?
Over the last 2 centuries, we've lost about half of the wetlands in the United States.
That's Dwayne Havorka.
I'm a public policy guy.
Specifically in the agricultural arena, Mr. Havorka believes that regulations are an expression of our country's values.
And one of our values is protection of our natural resources. And Congress started realizing, and society started realizing the many myriad benefits of wetlands in our society and their public benefits. And so many of the decisions that farmers make on day-to-day operations can have a pretty big impact on our natural resources. So it's really important that our public policies help those farmers protect those natural resources and help all of us enjoy the public benefits that come from those natural resources.
So, in 1985, Congress created what are called Swampbuster provisions.
Ghostbusters was a big movie in the early 80s, and so they named them and they stuck.
Swampbuster provisions give farmers access to certain federal funding programs if they comply with a set of rules protecting wetlands.
A lot of what we do in federal agricultural policy is provide incentives for farmers and ranchers to do better things with their land, to do things that will protect those public resources. This is the string that's attached to federal farm money for farmers. They got to do Swampbuster, they got to protect their wetlands. So it's really important to understand what would happen if this provision wasn't there. And what would happen is that millions of those wetlands would be drained by now. So farmland is very valuable, and so I think what's very clear is there's a whole lot of interest in landowners who would be draining those wetlands if it weren't for the Swampbuster provision.
Ms. Talley views this carrot and stick method to be an example of government overreach. She thinks it's not realistically possible to refuse the Swampbuster funds.
It's not like you can just choose not to be part of them, because the entire agriculture industry is part of them, and all of your competitors are part of them, and they're priced into how you do your business and how you run your family farm. If you either run afoul of regulations or their own rules, they can call your loans, they can deny you subsidies, they can deny you access to the programs, and the Bouchers found themselves in the middle of that as well as their immediate problems.
The USDA believed that the Bouchers had violated the Swampbuster provisions when they cut down the trees on their property the USDA believed was a wetland. USDA representatives found out about the trees 8 years after their removal, in 2002, while visiting the Bouchers' land for a different reason. The Bouchers claimed the trees did not live on wetlands, and the agency was mistaken in its analysis, and they appealed the decision.
Mr. Boucher believed the appeal had been resolved in his favor because he never heard anything further.
About 8 years later, the Bouchers, and by this time it was just Rita Boucher, her husband had passed away, was looking to knock down a building on the farm. So they went to USDA and asked for permission to do that to make sure they weren't going to cause a problem. And USDA pulled out the file, and when they were reviewing the farm, realized there was never a final wetland determination. So they still have just this preliminary determination from years earlier that was still hanging out there.
There is no explanation that has ever been provided by the agency with respect to how 9 years elapsed, beyond an explanation that the agency actually has no requirement in the code to continue to follow up on an initial determination. They basically explained it away by saying it's not our job to make sure we do things in a timely manner, it's just our job to make sure that we do them.
The USDA stood by its earlier determination, but Ms. Boucher stood her ground. They ended up in federal court 20 years after that fateful day when the late Mr. Boucher removed the trees from his property, and the Seventh Circuit decided that the USDA was in the wrong.
The court found there was no hydrology on these sites, and therefore these are not wetlands, they cannot be converted wetlands, and they remanded the case to the district court to grant Ms. Boucher relief accordingly. But essentially it came right down to the fact that the agency shifted its position, engaged in a bunch of circular reasoning, and the clearest and most concise and convincing evidence that was presented here was presented by Ms. Boucher.
So the Department of Agriculture employees were doing their best to follow the guidelines and figure out, is the hydrology there or not, and to figure out, would hydrophilic vegetation grow there or not. And I think it looks like from the record that they made the wrong call. And there were several opportunities along the way when USDA could have corrected the mistake, and they didn't.
The court, even the appeals court, in the final decision about the Bouchers, even says, this is too complicated for any layman or even this court to get into. And when you stack all these agency powers and all these twists and turns of the process is really the penalty for a lot of these people. And even though the agency processes are supposed to be fair and there's safeguards and things like that, it very much feels like it's me versus this giant government that I can't control, and everyone is against me, and I have to prove to them somehow that they're wrong. And that's a huge uphill battle when everything that you have, your livelihood, and especially for family farmers, it's not just their livelihood, it's their home. Having that tied up for months or weeks is one thing. Having it tied up for years with no relief is completely devastating.
This is a horrible thing for people to go through, to have the uncertainty, to then go to the expense of trying to make your case and collect as much information as you can, and then make the case and get turned down and have to go to court, and then again have to go to another court in order to get a decision. So it's, I feel for the family. It's a lot of lawyer costs, it's a lot of other costs and a lot of uncertainty that they had to go through.
Ms. Boucher was entitled to receive all of her costs and expenses, including her attorney fees, back because she proved that she was right at the end. So if you know that you're right, you have the ability to recover that cost. Now, you don't get the time back, and the time commitment can be huge.
When I deal with big corporate clients who have access to the best lawyers and masses and masses of resources, their own experts, and they can really fight this stuff, that's one thing. You're a power fighting a power. But when it's a family farm or a small business or things like that, they don't have access to hordes of corporate lawyers. They don't have access to their own experts to battle the government experts. Normal people, small business owners, family farmers, the Bouchers, are stuck in years and years of red tape and trying to prove that they're right and the government was wrong. And again, it took them decades. Mr. Boucher didn't even live to see the vindication of his case. The Boucher in this case is the widow. That's how long it took to vindicate a few trees that were taken down in the 90s.
Mr. Hovorka pointed out that the agency's appeals process is designed to avoid the courts, which is typically where these cases are most painful for litigants.
So USDA provides some easy buttons, some easy ways to appeal decisions that are fairly low cost. You can appeal it to your county committee, you can talk to them, you can appeal it to the state conservationist. Ultimately, when it gets to court, that's when it gets expensive. And so I think USDA does a pretty good job of giving people alternatives to going right to court, to work your way up through the agency. The key is that those have to work, that the agency has to be open to information, has to be receptive to those appeals, has to be willing to correct mistakes if they were made. So I think this case, in part, is an outlier. That's why it was so big, is because there aren't thousands of these cases that are going up the chain through the courts. This is an outlier to me, but it also demonstrates the things that we need to do better.
The interesting thing about agencies is they kind of act in some ways as all three parts of government. They pass these regulations, they enforce the law, they go investigate things, make sure people that are following the law, and then they also determine whether or not you've broken these regulations. So it's really interesting in that we think that we have a divided government, that different branches are supposed to do different things, but in agency world, in regulation world, it's generally you're dealing with one agency for all three parts of the process.
In Boucher versus USDA, we see that the government has to balance two obligations: protecting our natural resources and upholding the liberty of its citizens.
And so when you ask about Bouchers and this case, it's not just about the Bouchers, it's not just about what a wetland is or isn't, and it's not just about the science or the process. It's about a family that got caught up with the vast bureaucracy of the United States Department of Agriculture. It's about a family that thought that they were doing the right things and minding their own business and following the laws, and didn't even know for a period of time that the government thought otherwise. It's about how an individual family interacts with the government and how important it is that we understand what this vast power of the government can do to an individual. So we have to think about those things, not just what these regulations are doing or what they're intended to do, but how they affect individuals on the ground.
Where to draw the line between these two interests is for you to decide.